Good morning, everybody. So this is the 1st of May, as you may know.
Yeah.
And in celebration, I was planning to wear my shorts, my flip-flops, and flowers in my hair. It didn't work. I want to start this morning by introducing and thanking the members of the Bucket Committee who have brought this series of talks to all of us to enjoy. Judy Hunter is the chair and stuck in, I don't know, the air or Chicago or someplace not here, sadly. But we thank Judy very much. And I wonder if the rest of the committee members would stand. They are Joanne Britton, Mary Shirkman, Nisha Worley, Jack Gustafson, Bob Weimer, LaForest Sherman, Barbara Hansen. You can stay, you're standing, Barb, so good. George Drake, you don't have to stand if you don't want to. Ben Gunther, myself, Janet Carl, and we'd also like to thank Monique Shore, who's our library liaison. So let's give the committee. You have evaluations on at your seat, and they cover the speakers for the final 3 weeks of the semester. Please make your comments, and any other comments on the back that you want to make, and you can turn those in at break or at the end out at the table out front. Welcome to our visitors who are here, who may not have been here before. So it's exciting to give the same 3 announcements that I always give because there are new people to hear them. So if you're using a T coil this morning, it's time to turn it on. Time to turn off or mute your phone if you haven't. And if we have use of the microphone, I'm not sure whether there'll be questions or answers. Will there, George?
Well, I hope I can
We'll get
allow
to
some time
that
for
way.
that, yeah.
If there's a question and answer period, if you raise your hand, I will come to you with the mic. And again, for the new people, this mic requires getting right up close to your face like this, closer than you'd like it to be, and holding it like this, not like this. Okay. We are delighted to welcome George again to our speaker's podium. He doesn't need much of an introduction. I will simply say he is a beloved member of our Grinnell community. He's been a student, an alum, and president, and history department member at Grinnell College. And he is speaking on Americans we should know more about, John Marshall. Welcome, George.
Thank you very much, Janet. Can you hear me okay in the back? Okay. And I am going to sit. I have to thank Christopher French, who did the bucket course last week, because I was scheduled to do it then. And that would have been 2 weeks after a total knee replacement surgery, and I think I'm doing better with 3 weeks. So he was quite gracious in saying, well, we can switch. And I want to do another shout out to the Bucket Course Committee. As you know, Joanne Bunge created this entire enterprise, which has become a community institution. And when I get up here, I see friends and neighbors. This is really, and as a consistent member of the audience, why I personally really do appreciate all of it. We've had a terrific series this year, I think. And thank the committee. And yeah, Jack's got some more of the handouts, so if you don't have one, you can bring them around. I particularly want to note Jack and Bob Weimer. You know, they get up at the crack of dawn to come over here and position these chairs, get everything set up and so on. And it's a terrific committee. People do different jobs on the committee. I'm probably the laziest one on the committee because my job is to help find people to give the lectures and try to persuade them to do it, and I'm one of a couple of people who do that. But it's a very hard-working group, and it really meshes exceedingly well, and the success of this enterprise is due in large part to that committee. Jack's got the handouts. This is low-tech George again. I'm right in front of the screen. There's not going to be anything up there. I hope it doesn't bore you if you don't have lots of PowerPoint. But you do have a handout, and I will just mention a little bit. Obviously, there's a wonderful portrait of John Marshall. which is on the cover of the Richard Brookhiser book, and that allows me to go back a couple of pages with the bibliography here. This is just a really brief bibliography for Marshall, but Brookhiser is one of those, the most recent one. The John Marshall Definer of a Nation, Gene Edward Smith, is one I suppose I relied on most heavily. It's a wonderful biography. And if you really, really, really are into John Marshall, you could read the great classic by Albert Beveridge, 4 volumes. I'm not expecting most of you to run to that. Brookhiser is pretty short, 270 pages or so. So if you want a quick overview, that's a very good way to get into John Marshall. The others, we've got some pictures here, more portraits of Marshall, and then you wonder why on earth this, you know, people in debtor's prison. One of Marshall's contributions, not as a Supreme Court justice, but as a member of the House of Representatives in 1798, was to push bankruptcy legislation. He drove that through the House of Representatives. So we had our very first bankruptcy laws, largely thanks to John Marshall. So that's why that's there. Then chronology, and then I'll refer to this during the lecture occasionally, the Article 3 of the Constitution. Not very big. Look at Article 1, which is the Congress, and which is really interesting today with what's going on nationally, where the Congress is supposedly trying to exert its authority. And what with our Constitution makers, they were mostly focused on the Congress, on the legislature. In a way, it was even, as I'll say in a few minutes, a little bit of a stretch for them to include something on a high court, Supreme Court. But when you look at Article 2, which is the presidency, it's pretty skimpy as well. But things have historically changed a lot with the growing role of the presidency and the somewhat shrinking role of the Congress. But that was not the intent of the founders. So in talking about John Marshall, I'm actually talking about one of that founding generation, not president of the Constitutional Convention, but very involved in the adoption of the Constitution, and certainly involved in making the Constitution a living, breathing reality in American culture. So anyway, thank you all for coming. I will give a shout out to a group of Grinnell alums. They don't happen to be classmates of mine. I'm much older than them. They're early 60s folks who are here in a kind of a mini reunion, and I know those folks well and said, well, why don't you come? So I created problems for us by inviting them to come along. Well, I will sit down now. My interest in Marshall, you may remember, some of you, that I did a series of lectures on the Constitution. I'm playing around with being a constitutional scholar. I'm not. I'm certainly not a lawyer. So people like Don here and so on can be interested in their reactions. And by the way, if I'm being obscure or there's something that really you want to ask, do so. Just we'll, as we go along, and I will try to answer those questions or comment anyway. But you know, the question of how did we get here the way we are today with the Supreme Court? Think of how important that is. Brett Kavanaugh. I mean, how we were, I don't know about all of you, some of you were actually working, but if you had the time to be riveted to the television, it was a little like the Army McCarthy hearings back in the 1950s. Some really riveting television, and simply about the confirmation of a nominee to the Supreme Court. But that confirmation, if confirmed, that nominee was likely to tip the Supreme Court in a certain direction, a more conservative direction. And when you think about it, that's enduring. I mean, we have elections every 2 years. We elect the president every 4 years. We don't elect our Supreme Court justices. They serve at good behavior, as it's called in the Constitution. They're lifelong appointments. So you can, in shaping the Supreme Court, create a major part of the government that is stably in one direction, as through electoral processes things change with the Congress and the presidency. And how did the Supreme Court get to that point that it would be so important, that it was really important as to who is nominated and who is confirmed in the Supreme Court? There's no way, as the Supreme Court began, that it had that kind of stature. It was a tack-on in the Constitution. But it obtained that stature in the Chief Justices of John Marshall from 1801 to 1835. A very long period, serving as it said in the section that was advertised in this lecture. John Adams was the one who appointed him. Thomas Jefferson, served under Thomas Jefferson. James Madison, James Monroe, John Quincy Adams, and Andrew Jackson. That's an incredible span. And I'm going to get into the politics of it in a few minutes. But the Supreme Court is a stable Federalist force as these administrations shift, and policies of administration and Congress shift. But you have this very stable, consistent kind of, if you want to call it political, but a way of interpreting the Constitution that lasts through those 34 years. And that is a creation, I would maintain, of John Marshall. Now, just a little bit of background about the Supreme Court as it was at the time that John Marshall became Chief Justice in 1801. In the Articles of Confederation, which was our original Constitution, created during the Revolutionary War, there was no High Court. There wasn't an executive either. There was a committee, but it was totally a legislative operation. So in the Constitutional Convention, they created two new forms of government, that is to say, an executive and a judiciary. Article 3 of the Constitution on the back of this is the article that sets up the Supreme Court. Also, there was in 1789, very shortly after the government began, a Judiciary Act that was passed by Congress and approved by President Washington, which created district courts and courts of appeal. And you'll see it if you look at the back in Article 3, and look in Section 1. I think that's, yeah. The judicial powers of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. So it's by congressional act that you create the district courts and the courts of appeal. And we still have them, obviously. We hear about them quite a bit. The first three Chief Justices were not particularly strong. John Jay, who was a major figure among the founding generation, was dragged into being the first Chief Justice, didn't want to do it, and very soon began to do other things. Two of the first three Chief Justices became foreign diplomats. One, Jay, sent to England to negotiate a treaty, and the other, Oliver Ellsworth, who was sent to France to negotiate. That's why they're Chief Justice. So they had lots of time to do other things. In the first 2 years, for year and a half of the Supreme Court, they heard no cases whatsoever. In the next 10 years, 1790 and 1800, they had 63 cases. So they weren't doing much. I mean, it's a part of a government that's trying to feel its way, trying to find what sort of role it's going to play. And it's with John Marshall that actually that role is determined. Now, the parties at the time. In theory, there were to be no parties. Washington hated parties, hated the whole idea of parties. But as today, so back then, there were very different attitudes toward the role of federal government. How forceful, strong, and invasive in our lives should the federal government be? And we're still arguing about that. Big government versus small government. You also have the fact that it's the states who come together in the Constitutional Convention in 1787. Their representatives create the Constitution. And so the states are there with constitutions of their own before we have a federal constitution. So, and we're still bedeviled by this, aren't we? What's the role of the states within this federal system? states' rights. Well, how independent are the states to be within this federal structure? And there were a lot of people at the time who either opposed adopting the Constitution because they already thought it was far too invasive in individual civil rights, and others who were willing to go along with the adoption of the Constitution, but wanted as, what shall I say, as benign a federal government, national government as possible. Whereas others, and George Washington was the leader, Washington was so invested with the problems that he faced as the general of the Continental Army fighting that war with a Continental Congress that failed to support this national effort. And the states were more looking out for themselves more than they were for the national interest in the Revolutionary War. We couldn't get money for his troops. It was chaotic. And we won that war largely because Britain finally gave up and France came in and helped us. We did a lot on our own, but not enough to retain independence on our own. So Washington had struggled with the weakness of the national government. And individuals who had been part of his army, thinking particularly of Alexander Hamilton, but also of John Marshall. John Marshall served under Washington as a captain in the Continental Army. They were acutely aware of the lack of support from this national government. So they tend to emerge from that milieu as what were called Federalists, who believed in a pretty strong and forceful federal government to bring us together as a nation. Not just an assembly of individual states, but as a nation called the United States of America. At the preamble of the Articles of Confederation said, I forget now the exact words, the states, and it starts out, we are the states. What's the preamble of the Constitution? We the people of the United States of America. There's a forceful Federalist statement. And Marshall was deeply invested in that. He always argued the Constitution is the creation not of the states, but of the people. Of we the people. We are a nation. The nation comes first, the states are second. And in that early period, it was hard to make that shift from thinking of yourself as a Massachusettan or a Virginian into thinking of yourself as an American, part of the United States. You're both, but which is predominant? Well, the Federalists are the ones who want a forceful federal government. The Republicans at that time, which, by the way, in our crazy, crazy political structure, the Republicans are really the original origin of the Democratic Party today. When we have a Jefferson-Jackson Day dinner to celebrate every year in Iowa, celebrating the Democratic Party. So Jefferson and Jackson are seen as the great founders of the current Democratic Party. But initially they were called Republicans, and these were the small government folks. Now Jackson's going to shift it, but Jefferson definitely is individual rights. The author of the Declaration of Independence, that's Jefferson. It really is Jefferson. And he wants as small a government as we can successfully manage. He doesn't want no federal government, but he wants it to be small. He tends to be a states' rights person. He was the author of the Kentucky and Virginia resolutions at the time of the Alien and Sedition Acts, where they were the first effort to nullify federal power. They said, we of Virginia and Kentucky aren't going to go along with the Alien Sedition rights. We don't believe in them, and we don't have to follow them. That's Jefferson. The individual rights and states' rights above the federal rights. So the irony of, in some ways, the irony of John Marshall's appointment, he was appointed, what's the word I'm looking for? Adams has lost the election. Jefferson won't be president until March of 1801, and Adams appoints John Marshall as the Supreme Court Justice in January of 1801. So Jefferson's going to be the president, but he's going to have to contend with John Marshall, a Federalist. You're going to get moved, and not only did Jefferson win the election. The Republicans won the election, both in the House of Representatives and the Senate and also in the presidency. So we're shifting from a Federalist. We only had 2 Federalist presidents, Washington and Adams, and we're shifting in this party structure to a Republican approach. But the Supreme Court's going to remain as a Federalist bastion throughout the time of John Marshall. And, he wanted Pope to keep the court out of politics, but there's no question that he had politics. And when in our history has the Supreme Court not had politics? We certainly see it today, but it's not unusual what's going on today. So this is the party situation. By the way, the Federalists tended to be Northeasterners, New England versus the Southerners who were Republicans, and Virginia particularly. And the Federalists are going to, except for the Supreme Court, are going to go, essentially disappear. We only had 2 Federalist presidents, and a number of things happened, including their vocal, vociferous opposition to the War of 1812, and they became identified as very non-patriotic at that point. But they drove themselves into exile and never do emerge again as a major party, except for their presence in the Supreme Court. So again, emphasizing what we see today, that whoever, how can you, the importance, I guess, I would say, of the appointments to the Supreme Court and their longevity. Now, I'm going to get into the fact that there are going to be a succession of Republican appointees to the Supreme Court, but guess what? Marshall controls all of them. That's one of the most remarkable things is how Marshall managed to put his imprint on the Supreme Court when you've got Jefferson, Madison, Monroe, those 3 in particular, appointed Republican after Republican to the Supreme Court. But yet the Supreme Court remains a Federalist bastion. I'll talk about how Marshall did that in a little bit. Okay, so I think needless to say, Jefferson was very upset over the appointment of John Marshall by Adams. I thought it was really quite unfair. And Jefferson and Marshall actually were second cousins, I think. They were related to each other. But they had a visceral dislike of each other. A visceral dislike of each other.
They both had slaves?
They both had slaves. Yeah, I'll mention that right now. Because given today's historical arguments, Marshall's attitude towards slavery is important. He had slaves. He was a founding member of the Colonization Society, which persisted from the early 19th century right through Lincoln. Lincoln was, I believe, in colonization too. In other words, let's get rid of the slaves. Let's free them eventually, but let's send them away. Let's send them back to Africa or to Panama, or they're looking around the world for places that they could send them. Because most of them didn't believe we could live together. Ex-slaves and his freedmen and whites. It just wouldn't work. So that was essentially, he was enlightened for his time. He had slaves. I think he had a dozen or so slaves. Never did release them, but did see that slavery was it should be a disappearing institution. So he was thinking about how we would move forward without slavery. So, but that's a whole historical argument as to, but Marshall is not by any means pristine with regard to slavery. How did Marshall manage to control his colleagues on the Supreme Court? He had a marvelous personality. Everyone liked John Marshall. There are countless accounts of people meeting him, this great man. First of all, he was, and Sue will admire this, he was slovenly dressed. Sue tries to get me to look appropriate. And sometimes she succeeds and sometimes she doesn't. But People were disarmed by John Marshall because, you know, he wasn't dressed very well, and he was relaxed, convivial, not at all in personal relationships and imposing figure. Just a very likable guy. And he took advantage of that. And they claim that Madeira, that is to say Madeira wine, was one of his chief tools in bringing along his colleagues, because he would entertain them. And it's really, really, this is probably the most important thing. The government has just moved to Washington, D.C. In fact, that brief period when Marshall was Secretary of State, John Adams, who much preferred to be in Quincy, Massachusetts, the summer the move took place, he went off home. And so John Marshall, as Secretary of State, oversaw the move of the government from Philadelphia to Washington, D.C. So that's another one of his interesting contributions to our national life. Well, this was a really rough and ready place. I mean, it's just created out of nothing, D.C., you know, such a swamp. And they've got a few buildings and some hotels and boarding houses and so on. So what happens, the Supreme Court justices all board together. They live together, eat together. So they would, you know, they would hear cases in the afternoon or late morning, and then go back to their hotel for dinner, and then have a conference that evening over Madeira. Now, imagine what would happen today if the Supreme, I don't know whether they slice each other's pieces or not, but they seem to like each other, actually, even though they're at odds politically. But I mean, think of that's got to be the key. This very convivial, easy to get along with, but forceful intellectually and in other ways, person who supervises their living arrangements and their eating arrangements and so on. Another interesting story is that when they had the Virginia Ratification Convention for the Constitution, and that was a tough convention. Patrick Henry was the leader of the anti-ratification forces, and it was, you know, even though you had people like Madison, who essentially created the Constitution there, and Marshall and so on, it was a very close vote. It was a very near thing as to whether Virginia would ratify. But Marshall lived in Richmond. That's where they're meeting. And he would entertain the delegates in the evening at home. Again, you know, he just, that kind of person. So just very clubbable guy, a very clubbable guy. So that had a lot to do with his success, I think, with the court. And so Republican nominee after Republican nominee would fall under his sway, and under the sway of the conviviality and the general consensus-forming kind of court that they were. Most of their opinions were unanimous. There were very few dissents. Marshall wrote about somewhere between half and 2/3 of the opinions. So he's the dominant force in virtually every way. And so he creates a sense of we should not disagree with each other. When we come finally to our opinion, and he was the one who created the phrase, the opinion of the court. The opinion of the court is John Marshall's phrase. It should be a unanimous opinion. So let's work together to see if we can't come to that unanimous opinion. So it was really, really rare to have a dissent out of those 34 years of the Marshall Court. It got a little worse toward the end, and his control and control toward the end of his tenure was somewhat less strong than it was earlier. The majority of the justices did not have formal legal training. Marshall himself was one of the few who did. It was really about a 6-month stint with a man named George Wyeth at William and Mary. And it was while he was in the Army, in the Continental Army, but he was on leave. They typical of the Continental Army. Sometimes they were in the field, sometimes they went home. And he was at home in Richmond, and so he took that opportunity to go to Wyeth's lectures. And actually, with him at that time in those lectures was a man named Bushrod Washington, who was George Washington's favorite nephew, and when Martha died, he inherited Mount Vernon. And Bushrod was appointed to the Supreme Court in 1799, 2 years ahead of Marshall, but he was one of Marshall's, he was another Federalist, and another of Marshall's very close friends. And Washington had the same experience with Wyatt. Blackstone's commentaries on the English law had come out just a few years earlier, and Marshall was very, very deeply invested in Blackstone, also in English common law. So most of the lawyers and justices and so on were primarily self-taught or, apprenticed with lawyers and so on. So he's part of that era, but he had a little more formal training than the bulk of his colleagues. So I'm going to get into Supreme Court cases in just a few minutes. But just to mention some generalities about Marshall's legacy. Oliver Wendell Holmes was quoted as saying, if American law were to be represented by a single figure, skeptic and worshiper alike would agree the figure could be one alone, and that one, John Marshall. And the Gene Edward Smith biography had, I thought, a wonderful short statement. Thomas Jefferson was best when articulating a philosophy of government. John Marshall at his best when applying one. He applied the philosophy, and Jefferson was sort of that way. He had wonderful, wonderful soaring statements, but application sometimes was not his forte. And I would say, just to, again, before I get into some of the actual cases, I've sort of put this down. He sort of put muscle into the Constitution. And I think it's Marshall who makes the Constitution into the icon that we feel today. Because the way that his court would focus on the Constitution and constitutionality of actions and laws and so on. So Marshall's the one who brings together the actual legislative process and the Constitution in judging whether the legislative process is in conformity with our Constitution or not. So that sets the Constitution above the law, really. And the law then needs to conform to the Constitution, and that's what Marshall essentially accomplished. And so we've got about 5 minutes, and I think maybe I can get into the first of these cases. I'm going to take only one of these cases, and here I'll look at Don here occasionally and see how far I'm going astray. The famous Marbury versus Madison of 1803. So this is 2 years into Marshall's tenure as the Chief Justice. And every time I've read about this, I've been totally confused as to what the case was about and why it was so important. Because it's out of this case that the Supreme Court manages to solidify its role as the interpreter of whether law is in conformity with the Constitution or not. Judicial review. I mean, the most fundamental of the powers of the Supreme Court is in this process of judicial review. So I'll at least get stuck. Yes, I think maybe I can finish this. So, what was the case? And Marshall's involved in this in some interesting ways himself. He involved actually in a mistake that he made. Adams is busy trying to get as much federalism into our court system as possible. So 2 days before he leaves office, he appoints 42 justices of the peace. Obviously, not from Jefferson's point of view, a very good thing for him to have done. So the commissions, these are all commissions, and they're on the State Department's desk. Marshall's State Department. And they never get delivered in those 2 days. So they're still sitting on the desk when the next Secretary of State, James Madison, comes along and just sort of shoves them aside. So the appointments aren't made. Hooray! Marshall forgot to send these appointments out so that they haven't officially happened. So we can just erase what Adams has done. Well, 9 months later, William Marbury, who was one of these appointed justices of peace, secured a writ of mandamus. And I'm probably mispronouncing that, but this actually came out of the Supreme Court, which essentially said to an administrative officer, do your job. In other words, James Madison, these appointments were made, send out those commissions. Madison ignored it. Okay, there's the case. Also, as a background, there was a big fight going on over the 1801 Judiciary Act that the Federalist Congress had passed just before the Republicans come in. And that, among other things, that Judiciary Act appointed 16 new district court judges who would all be Federalists. Well, in 1802, along comes a Republican Congress and a Republican president, and they pass a law to nullify the 1801 law. Now, the Constitution of the question was, can you, by law, remove judges? They're supposed to have lifetime tenure. And the only way you can remove them is by impeachment. So this is broiling at the time that the Marbury versus Madison case comes up. Okay, so the Supreme Court is now going to hear this case that James Madison had not sent out these commissions, and he is required to respond to a writ of mandamus, which says to Madison, do your duty, do your job. All right. Okay, the case is heard. Madison was not even represented. Marbury is represented before the Supreme Court. Madison's completely non-represented. So it looks as though things ought to favor Marbury, right? I mean, what we're aiming to the point is that Marbury doesn't get the job. Marbury's going to lose the case. But the Supreme Court and the Constitution are going to win the big case. All right, and I'm going to go over a little bit because I think I shouldn't stop this. Let's go. The opinion actually was announced in the parlor of Stella's Hotel, where the Chief Justices were living, and one of the justices, well, all the justices were living. Chase was an invalid at this point and couldn't get out. By the way, at the Capitol, they had a little teeny room in the basement of the Supreme Court. I mean, it was really their quarters, and they didn't have anything but the courtroom. They had no chambers or anything like that associated with it. So doing this in the hotel might have been more comfortable than doing it over in their official quarters. And the opinion states that the writ of mandamus does require Madison to do his job if the writ of mandamus is appropriate. If the writ is appropriate. Well, the Supreme Court has appellate jurisdiction as determined by Congress. It has original jurisdiction as determined by the Constitution. So let's look at the back here. And I want to look in Section 2, second paragraph. In all cases affecting ambassadors, other public ministers and councils, and those in which the state shall be a party, the Supreme Court shall have original jurisdiction. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. So original jurisdiction is public ministers and councils, those in which the state should be a party, and by the way, that's going to be changed by a constitutional amendment, the 11th Amendment. The Supreme Court shall have original jurisdiction. Well, there's nothing about a writ of mandamus in that. Yet the writ of mandamus was issued by the Supreme Court according to the 1789 Judiciary Act. The problem was the Judiciary Act cannot insert a writ of mandamus in a constitutional provision. So the law is illegal. The writ of mandamus law is illegal because it was an original jurisdictional action. It hadn't come by appeal, it had come originally. So that's the conclusion of the court. The writ of mandamus should never have been issued by us, by the court, because it was unconstitutional to do so. So you see what, I mean, it's a fairly complex case, and it looks so minor, and yet it becomes so major because the Supreme Court has asserted its right to judge whether a law is a constitutional law or not. And it's accepted by the Republicans because they got what they wanted. I mean, in terms of politics, it's a brilliant win-win kind of thing. Republicans don't object. Here's an assertion, a huge assertion of federal power through the courts. Huge assertion. But they don't object because Madison won the case. And Marbury didn't get his job, didn't get to be a JP. So the reason I spent a little time on this, and I did, spent a lot of time trying to figure out what's going on, is that it shows how brilliant was John Marshall in negotiating a very conflicted environment around this 1801, 1802 judicial act. The first one passed, and then it comes along and they nullify it. So the whole business of courts and so on is very much in center stage, and yet he managed to slip through this huge assertion of judicial power to interpret the Constitution and the laws that are passed under the Constitution. So, having said that, it's a little late for our break. We'll take it.
It's all good. We're going to come back in 10 minutes by that clock, so shortly before 5 up.
Thank you, Janet, and thank you all for coming back after, wow, we've really got nice refreshments today. But as I recall, that's the way we ended the year, with some really good goodies. The chronology that I gave you does at least mention a lot of the cases, all of the cases I guess I'm going to talk about. And I'm not going to go into the excruciating detail for the other cases. Most of them I think are not quite as complex as Marbury versus Madison, but also there just isn't time to do that because I would like to allow us some time at the end for discussion and questions. In 1810, I mean, what I'm doing here is picking out the sort of salient judgments of the Marshall Court. There are a lot of important judgments, and they were. Remember, I said there were some like 63 cases between 1790 and 1800. They were hearing anywhere from 40 to 60 cases a year in the Marshall years. And they had only one session of the court. And the 1802 Act, which the Republicans passed, and this was Thomas Jefferson putting the needle into the Supreme Court, put the Supreme Court justices back on the circuit. Every one of them had to be judged in an appeals court in a circuit. So they were more often, Marshall Circuit was headquartered in Richmond, and he was more often in Richmond, his home, than he was in D.C. because they were more often on the circuit. So they were, the Supreme Court justices not only are hearing cases in Washington, but they're hearing cases out in courts of appeal all over the East Coast, which was essentially America at that time. They just heard a lot of cases dealt with. So the Supreme Court's very active. So these are just very, very few of the cases, but there are salient cases with respect to constitutional law. Fletcher versus Peck, which has to do with sanctity of contract, particularly with respect to property. This is a really interesting one and somewhat complex, but I think I can discuss it fairly quickly. It had to do with what was called the Yazoo land purchase. Land sold by the state of Georgia in 1795. It was a lot of land, essentially all of Alabama and Mississippi today, put up for sale. There was even a question of whether they had the right to do it. They claimed that territory, And it was a bit of corruption, no question about it, because the individuals in the legislature in Georgia were getting a lot of the money for these sales. So they were a sort of shaky situation. And in 1796, there was another election, and most of these members of the Georgia legislature were thrown out. And the new legislature canceled those sales. A lot of people had bought the land. It was really cheap. And a lot of it was bought in New England. People were far, far away from the land itself. And one of them was a man named Fletcher, who bought from Peck. And then the Second Act, 1796, withdrew all of those sales. And Fletcher said, "You can't do that. This is my land. I paid for it." So the question is one of sanctity of contract. There was a contract struck for those lands, and can a law change a contract? The laws of Georgia change. And the opinion of the Supreme Court and Marshall's Court was that a state cannot take away land rights by change of the law. Land rights are sacred. So they were protecting the rights of that sale. Now, clearly it was a very complex situation. And the Supreme Court ruling is the one that's important in terms of longevity, that laws can't change, contracts are essentially sacrosanct. And, but it turns out that it was such a mess that I think it was cleared up about, 20 years later when the federal government bought the land. The federal government sort of bailed out the situation. It paid off people who bought it and so on. But it was very, very messy. So essentially the judgment didn't do a whole lot to settle the messiness of the situation, but it did establish a principle of the sanctity of individual contracts. Now, a really interesting one, especially to me as a college person, is in 1819, the Dartmouth College case. This one is really interesting. The state of New Hampshire was at odds with the college called Dartmouth College in its borders. And particularly at odds with the Board of Overseers, who were a bunch of Federalists. By this time, the state government of New Hampshire was much more Republican. So what do? They cancel the charter of Dartmouth College, put it and throw out the overseers, put in a new board of trustees, put a new charter, and name it Dartmouth University of New Hampshire. The state takes over Dartmouth. Can that be done by a state? It's as though the state of Iowa decided, Grinnell College is a hotbed of radicals, socialists, and this Republican administration is going to take over Grinnell College and make it Grinnell University of the state of Iowa. That's about as raw as the situation was. And actually, Daniel Webster argued the case for Dartmouth College. He was a graduate. And he said, it's a poor college, a small college, but it's my own. Anyway, that was one famous part of his argument. Well, the Supreme Court found that the state of New Hampshire can't do that. That the charter of a corporation or a college is a contract. And you cannot change that contract, violate that contract. So it's another contract decision that made the sanctity of contract, in this case a corporate contract rather than a contract between individuals. So you've got it done at two different levels. With Fletcher versus Peck, individual rights, and the Dartmouth College case, you've got corporate rights. So that again establishes an important principle of law, and one of the points that's made about the Marshall Court is that by doing these kinds of things, they establish a kind of stability of commercial relationships in the United States of America that helps the country to develop, as it's developing very fast in the early 19th century. You need to create stability of business arrangements and of contract and so on in order to have any real prospect of growth and to open up the society for this sort of economic growth. So these acts of the Supreme Court were very important. The bankruptcy law that Marshall drove through in the Congress was important too, in order to create a more stable environment for doing business. McCulloch versus Maryland, same year, 1819, is another landmark case of the Supreme Court, and probably at the time of all the opinions of the Supreme Court in the Marshall era, the one that was most recognized right at the moment as being highly consequential. As I was trying to make a point about Marbury versus Madison, that was sort of snuck up on society and the government and so on as to its constitutional importance. Huge constitutional importance, but only gradually realized how important it was. Whereas McCulloch versus Maryland was immediately recognized as a really important and landmark decision, which limits the rights of states. And going back to that point, I mean, we're still with us. It's a really complex set of governments we have, because we do have strong states and a number of things. I mean, Don practices law in the state of Iowa over and over again. It's the Iowa Code that influences and dominates his practice, probably more than the federal code, I don't know. But our states have a lot of responsibility and rights existing within the framework of a very powerful federal government that we have today. And it's no wonder we can't, it's hard for us to sort this out. Well, McCulloch versus Maryland helps in that process. There was at that time a United States bank. And Maryland instituted a tax on the transactions of the Bank of the United States. The question was, could they legally do that? And so the manager of the U.S. Bank, branch bank in Maryland, a man named McCulloch, brought suit against the state of Maryland for that tax. We're not going to pay it. It's a federal institution, the state cannot tax it. And the opinion of the Marshall Court was that the Bank of the United States was established by federal law, which is the supreme law of the land. So if you do have a conflict between state law and federal law is supreme. That's the first important statement. The power to tax is the power to destroy. Ultimately, it's the power to destroy. And therefore, you cannot tax an institution that has been established by the supreme law of the land, because that means a state could have the option to destroy something created by the supreme law of the land by taxation. So that is essentially the judgment or the opinion of the Supreme Court. So, in other words, the law, I mean, in the actual case itself, the law is declared unconstitutional by the Supreme Court. And this, some people interpret this as not so much an increase of federal power as a diminution of state power. But it is a powerful case that asserts the supremacy in this conflicted, complicated situation between states and federal government, the supremacy of federal law. That's essentially the point that is made in McCulloch versus Maryland. And it was sufficiently in-your-face kind of opinion that the society recognized that. Yeah. It made a huge impact. There are even some people argue that the Missouri Compromise might not have been possible without the McCulloch versus Maryland decision, because you've got the federal government messing around a lot with states and territories through the Missouri Compromise. In other words, it gave the federal government more power to legislate with respect to the expansion of slavery. But in any case, whether that's in fact the case or not, some people have argued. All right, another case in 1820, the next year, Quahog versus the state of Virginia, asserts the right of the Supreme Court to hear appeals from state courts where federal issues are involved. And it happened to be a commercial situation, and the Commerce Clause of the Constitution was applied in this case. I'll get into the Commerce Clause when I talk about the next case, because it's even more central. So, yeah, you know, again, Don could tell you much better than I could. You know, when can you appeal from a state court to a federal court? You can't always do that. State courts are supreme in a lot of matters, but if it's an issue that has a constitutional federal issue, that is to say commerce, then you could appeal from the state court to a federal court. So that's, again, important with respect to trying to sort out that complex relationship between the states, who have their own judicial system, and the federal government, which has its judicial system. I mean, I confess, I mean, this is where I suppose lawyers spend a lot of time learning about that, because I confess it boggles my mind to think about where you can, where they cross over, where they don't. Now, Gibbons versus Ogden in 1824, which had to do with the freedom of navigation on domestic waters, and this will get into the Commerce Clause. Robert Fulton, inventor of the steam-powered boats, and a man named Robert Livingston, who was his associate, got a monopoly from the state of New York for steamboat traffic within the waters of New York. Huge. And the question was, could this monopoly be upheld? And the case is Gibbons versus Ogden. Ogden was operating a ferry, I forget exactly, I think it was between New York City and New Jersey, under the Fulton-Livingston monopoly. And a man named Gibbons challenged that because he had a federal license to navigate that space. Federal license versus a state license. Interestingly enough, Cornelius Vanderbilt was the captain of Gibbons' ship. As he was just starting out in his old transportation life. So, this is appealed up at the Supreme Court. And the opinion is, ask the question, can a state restrict commercial traffic under a monopoly? By applying the Commerce Clause of the U.S. Constitution, it was determined that a state cannot restrict traffic, this kind of traffic, through a monopoly. The Commerce Clause says Congress shall have power to regulate commerce within foreign nations and among the several states and Indian tribes. That's the famous Commerce Clause. Well, says the Marshall Court, this supersedes any law of the state of New York. Congress is the one that has the right to regulate these things, so federal licenses will trump state licenses. So Gibbons wins the case, and what it does, in really important, in opening up commercial regulations, so you're not going to have states determine anything. I'm a European historian, and all over Europe in the Middle Ages and so on, towns and areas would charge tolls for everything that passed through. You could have that. You could have, you're on the Mississippi River, and you pass from Minnesota waters to Iowa waters. You gotta pay a toll or have a license to transport. But no, you can go all the way from Minneapolis to New Orleans, and no state's going to be able to interfere with that movement. So there's the importance of that particular decision. Again, opening up opportunities for commercial enterprise. So the Marshall Court had a lot to do with creating the stability that commercial enterprise and growth require. Now, I mentioned the Worcester versus Georgia case, and I just mentioned that just briefly, and that was in 1832. As you probably know, and this is during the Jackson years, Georgia and the Cherokees who lived there were at odds. Georgia passed a law that no white person could live with the Cherokees without the authorization of the state. A man named Worcester was a congregational missionary to the Cherokees, was living with them along with his associate, and they were caught and sentenced to 4 years in prison for living with the Cherokees without a license. And this came to the Supreme Court, and Marshall said this was an unconstitutional inhibition on individual rights, plus that missions to, they even argue that missions to the Indians are something sponsored by a federal policy, and so on. This is the famous case where Andrew Jackson said, John Marshall has made his decision, let him enforce it. And I think that Worcester ended up serving a couple of years, because the state of Georgia defied the Supreme Court on this one. I mean, we're right on the verge of the Trail of Tears under Jackson, where they're going to move all the Cherokees out to Oklahoma and so on. So I just mentioned that in passing. Now, I'm going to stop. I think I can stop in about 5 minutes or so. I'm amazed, by the way, you know me, if you come to my bucket courses, I always go over. And I was worried because I have 5 pages of notes here, what was going to happen. But I'm closer to my notes than I usually am, so anyway, I think I'm actually proud of myself. I'm not, that's going on and on. I wanted to talk a little bit about the other things that John Marshall did. And Don asked me during the break, he said, would I say something about where Marshall stands within the pantheon of the founding generation? And Don said, you know, I think maybe he's up there with Washington. I would say that in terms of the reaction of their own generation, Washington was there all by himself. It's always interesting to try to figure that out because there are many, he had a huge number of flaws. But Washington was the great person of that generation. But I would say that James Madison I put very high because of his role with the Constitution. But I would say Marshall was up there, right, with that, in that level of the pantheon of our founding generation. We would be a very different country today without John Marshall and the Marshall Court. Because what he really does is put muscle and sinew into the Constitution. There it is, the Constitution. But, you know, everyone knew it. It had just been a committee meeting of about 55 people that put this thing together. But the states did ratify it. And so it gradually has to acquire stature and be applied and so on. And it's the Marshall Court that applies the Constitution and gives it that stature. So that's hugely important. But you think of the things that he did. Continental Army, and he had fought in several of the major battles of the Continental Army. His father was also colonel. Marshall was a captain. He was at Valley Forge. James Monroe was his roommate and cabin mate at Valley Forge. And he and Monroe, by the way, were very close. They had gone to school together. The only formal schooling he had was with James Monroe on the sort of frontiers of Virginia. And they also were very friendly when Monroe was president and afterwards. And they even vacationed together and so on. So that was a very close. Marshall was said to have been able to high jump 6 feet, not 7 feet, 6 feet during Valley Forge winter when they're, you know, fun and games. They're trying to do something to keep themselves occupied. That's pretty good, even today. But with no technique and so on. But anyway, he was thought of as a great athlete in that situation. Whether that's really important or not, anyway, I throw it out there. I did mention his role in the Constitutional Ratification Convention. He was one of the 2 or 3 major Federalist, Constitution supporters in managing to drive that through a very conflicted convention. Now, this one's really interesting. He was the U.S. peace negotiator under Adams in Paris to the Directory and to Talleyrand. He was trying to negotiate with Talleyrand. There were 3 of them, Pinckney and Elbridge Gerry and Marshall. Marshall was the leader. They spent about 8 months in 1797, and out of this came the famous XYZ affair. Because what Talleyrand says is, you can't even negotiate with us unless you pay us a bribe. This was the Directory, which was a very corrupt form, sort of part of the French Revolution. And Marshall consistently refused to do it. So they're there back and forth, they're there for 8 months, and they never do anywhere because of this insistence on the bribe. Gary said, let's pay the bribe, or say we'll pay it. And no, Marshall said no. And Marshall wrote the report of what happened, and which finally, it took so much time for things to get back to the U.S. When that report was published in the newspaper, there was a huge reaction against France, and that regime. And that sort of propelled Marshall into a considerable prominence, because he wrote the report. So he comes back, and then he gets himself, with Washington's urging, elected to the House of Representatives from 1798 to 1800. And I mentioned there in the bankruptcy law was probably his key contribution. Then, Secretary of State, not long, for about 8 months, but at the very end of the Adams administration, and also mentioned that he was superintending the move of the government from Philadelphia to Washington, D.C. And his appointment to the Supreme Court is really sort of interesting, because Adams first reached out to John Jay, said, come back, and Jay said no. So Adams and Marshall are in Adams' office discussing this, and Adams says, well, I guess I have to appoint you. And Marshall said, well, okay. So actually for several months, let's see, from January to March, he's Secretary of State and Chief Justice of the Supreme Court. So he remains as Secretary of State during those couple of months until the Jefferson government takes over. He presided in 1708 on the trial of Aaron Burr. I think John Knorr asked me about Section 3 of the Article 3 of the Constitution and the whole business of treason. And that, Marshall gets involved in this because Aaron Burr, he's already shot and killed Hamilton in 1804, and he becomes a pariah. Up until that time, he's been a major figure. 1800 election, he tied with Jefferson. And the House of Representatives had 37 votes before they broke the tie. And so he was Jefferson's vice president. So he's been a substantial figure. But he goes off to the frontier and sort of messing around on the frontier and having notions that maybe he could overthrow the Mexican government, or maybe even overthrow the American government. That's the charge that's made against him. He was gathering a military force near New Orleans to attack the federal government. And Jefferson is incensed. And he's publicly accusing him of treason and so on. So actually Burr is brought to trial. And guess who is the presiding judge? It's in Richmond, Virginia, in Marshall Circuit. He's the presiding judge. And again, it is related, John, to Section 3 of the Constitution with respect to treason. Here's a treason case. There was only one accuser that would testify. There need to be two. Plus, it was never quite clear whether he actually raised that army. He threatened to, but never clearly raised the army. So Marshall found him innocent, not guilty, in that trial. And again, Jefferson absolutely incensed. And Jefferson's neck is out a mile because he published in the papers and so on about this terrible treason that's been committed by Aaron Burr. Okay, now one of the most interesting things, and I'm going to stop here, 1812, he's asked by the state of Virginia to survey in the Allegheny Mountains whether you can connect the waterways of Virginia with the trans-Allegheny waterways. So he does, his dad was a surveyor, and he learned how to survey from his dad. So he takes time out from being Supreme Court Chief Justice in 1812 to go off with 20 people for a whole summer through the Allegheny Mountains on the survey route. That route now is U.S. Interstate 64. So if you've ever traveled that route at 64, that it was surveyed first by John Marshall. Again, wild, interesting things he's done. Then in the Virginia Constitutional Revision Convention of 1829, he pushes very hard for increasing the franchise. Franchise in Virginia at that time was a sort of Revolutionary War constitutional time, had substantial property vote, only men and substantial property vote. And they moved it, they made it more democratic, not totally democratic, because women weren't involved and slaves weren't involved and so on, but it was to be a householder and pay some taxes. And so greatly enlarges the franchise of the Constitution of Virginia, and so he dealt with that as well as the judiciary part. Okay, I'm going to stop. And we've got five minutes. No questions or comments?
Can you hear me? My name's Mike, and I've got a question regarding federal law versus state law. Is there not a federal law that outlaws the smoking of marijuana? If so, how can states then trump the federal law?
There is a federal law, I think, but not how, I mean, the state of Colorado, et cetera, would be. Don, can you help us with that one?
Help you with a marijuana question?
I don't want to touch that one.
I think that's kind of what the federal government is. We don't want to touch it.
Right up close.
The way this is happening is that the federal government is letting the states do it in most cases.
So not enforcement.
Right.
Not enforcement.
Not enforcement.
Eric from the back.
Hello, is that close enough?
Yeah.
You described the arc from Marbury all the way up to Worcester, and that Marbury is one of the first ones to establish the court as actually having significant power, or at least in retrospect. But Worcester seems to be very problematic because the way the executive branch responds, it sort of nullifies that power. And would you say that that's an arc on the rise, and then suddenly it declines, and the executive power suddenly rises at that moment? Or what is actually the legacy at that point?
Yeah. That's a very good question. The question is, when you have that Worcester case at the very end of Marshall's time, where both the president and the state are saying, we're not going to enforce the judgment of the Supreme Court, and where does that lead us? I'm going to say I wish I knew a little bit more about the case, because I think it was sort of semi-resolved but not totally resolved, and there's even a question as to whether Jackson actually said what I quoted him as having said, Marshall has made his judgment, now let him enforce it. But it's particularly important today with what we're dealing with today, when we have a Congress and a president at loggerheads, where the Congress is exercising its constitutional rights of oversight and subpoena powers and so on, and the president is saying, well, go ahead and try to enforce that. And what people say is it brings up a constitutional crisis. And I think we're headed in that direction. And which shows that within our, this is me, I mean, I'm not a great constitutional authority or anything, but that it shows that none of this is cut and dry. I mean, it has to be worked out through the courts. It has to be worked out with a certain degree of goodwill on the part of the government, individuals in government. And when you have this kind of defiance, then where do you go? You go arrest the president. Where do you go? And so, because our whole system is a series of precedents and history and working out, and then when you come to what may turn out to be one of our great constitutional crises in this current era, where are we? And I don't have the final answer to that, because we're not a dictatorship. We're a democracy, which requires a certain amount of goodwill in order to try to follow our laws.
Dave Ferguson, what is a constitutional crisis?
Well, what is a constitutional crisis is Dave's question, and I would try to define it as an issue where you have a constitutional mandate which is not either accepted or enforced. And then how do you, what's the enforcement? When you have a system whereby of law and so on, but you're dealing here at this level with most powerful people in society. It isn't just as simple as saying, if you don't obey the law, we're gonna drag you over and incarcerate you and try you and so on. Because there's even a question of whether you could try a president, sitting president. Probably not. So that's, I think, a classic constitutional crisis where you're supposed to behave in a certain way according to our law and constitution, and then you don't do it. And yet you're at a level where you cannot be forced.
So has there been a constitutional crisis that we can go study?
Watergate.
Civil War.
Well, yeah. The South Carolina, under Calhoun, nullification effort in the 1830s, it began during the Jackson administration, where it was a question of tariffs being enforced, and South Carolina said, we will nullify this. And it was finally resolved by force by Jackson. But, in a way, the Civil War was a constitutional crisis. Can a state willingly on its own withdraw from the Union of the United States of America? And the president of the time, Abraham Lincoln, said, no, you may not, that's unconstitutional, and we will force you to stay in. We fought a civil war for it, so that's probably the biggest constitutional crisis we've had. Gene's got a question, I don't think.
Gene Wubbles. I have two questions. I'll try to be short. Section 3 describes treason, and I'm wondering if there's another form of malperformance against the nation called sedition, and what's different between treason and sedition. And second, in the next sentence says, I'm confused about what the phrase saying, shall work corruption of blood or forfeiture except during the life of the person that named it.
Yeah, but the Congress shall have the power to declare punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. What I think that's saying is that it's not hereditary. You cannot inherit the treason, or attainder is an interesting notion too, because in the British Constitution they could pass a bill of attainder, which would say Gene Wubbles shall be executed. Parliament passed a law, bill of attainder, and you could be executed. The most famous case was the Earl of Strafford at the time of the English Civil Wars. They were going to try him, and they couldn't make a case against him, so they just gave up, threw up their hands, and passed the bill of attainder and executed him. So we're not going to have attainders in this country.
Well, let us all thank George Strait very much. This is, as we said at the beginning, kind of sadly, the last of our bucket classes, but you need only go without further education for a few weeks. Starting June 12th through the ACES summer class program, Andrew Graham will talk about water in the American Southwest, so be looking for information about that. Thank you all for your presence and your participation this year.